joining the Second Chance Act Grants State, Local, and Tribal Reentry Courts webinar. This webinar has been sponsored by the Bureau of Justice Assistance. My name is Hallie Fader-Tao from the Council of State Governments Justice Center. I'll be serving as the moderator for today's webinar. Before we begin, just a couple of housekeeping items. After the presentation, there will be time for a short question and answer period. To ask a question, please type the question into the Q&A panel at the bottom right-hand portion of your screen. You can ask a question at any time during the presentation, and we will do our best to get through as many of them as possible after the presentation has concluded. If you encounter any technical or audio problems during this webinar, please call WebEx Technical Support at 1-866-229-3239. Please understand that there are some technical issues that you may not be able to resolve. For this reason, we are recording this event and will post it on our website at www.nationalreentryresourcecenter.org. We should have a webinar posted online later this week, and once it's been posted, we will email you a link to the recording. Welcome. This webinar will introduce potential applicants to the recently released solicitation for state, local, and tribal reentry courts, which are funded through the Second Chance Act. Our presenters today are from the Bureau of Justice Assistance, Office of Justice Programs in the U.S. Department of Justice. Kimball Norris is the Senior Policy Advisor for Adjudication at BJA. In this role, she is responsible for numerous programs to improve the courts, including community-based problem-solving justice and assistance to tribal courts, in addition to the Reentry Courts program. Brenda Worthington is a State Policy Advisor at BJA. She is responsible for grant management for grants under the Second Chance Act, as well as being the point of contact for grantees in the Commonwealth of Massachusetts. We are lucky to have Kim and Brenda on the webinar today to introduce the solicitation. We opened last week and will be due on June 30th. After presentations by our speakers today, there will be time for a question and answer period. To ask a question, please type the question into the Q&A panel at the bottom right-hand corner of your screen. Please feel free to ask questions throughout the webinar. Without further ado, I will now turn it over to Kimball Norris.
Hello, and thank you everyone for joining us. We're going to start slide on the Second Chance Act. Many of you know that it was originally law in 2008, and it provides for several different programs. Today we're going to talk about the Reentry Court program, and the purpose is to help states and communities reduce recidivism. Advance slide, please. The funding status this year, the Bureau of Justice Assistance was appropriated $83 million for second chance programs, and that is split between anywhere from 3 to 5 different categories, plus technical assistance and training. Slide. The Reentry Court solicitation was released on May 17th. Applicants are due on June 30th. And you have there the link for the solicitation. Advance slide, please. Eligibility. If any of you have applied for this grant before you were this year, there's a change in eligibility. So I wanted to focus on that. This year, we are allowing nonprofits to apply, along with state and units of government and federally recognized tribes. And questions before about exactly what a local unit of government is. And so I want to just give some examples. State, a local or state probation, a parole, city or county public defender organization, or a city or county DA. Your local court is eligible to apply. And all those entities were eligible last year. And in addition, this year, we are allowing nonprofits to apply. Saying that, you'll notice the next bullet is under on the slide and in the solicitation, because if you are a non-court applicant, you must have a written agreement with the applicable court that details the establishment of a reentry court, a specialized docket, or court program. I can think of, I'll talk later about the difference between if you're doing it as under probation versus parole. But a good example that I can think of is if you're a parole agency, you need to make sure that your local court, you have an agreement with your local court on how you set up your reentry program, so they will know that you are in their local jurisdiction. You see there it's the overall goals. We're focusing this year on a lot of the evidence-based practices that are listed in the solicitation. Advance slide, please. The target population. Your program must target adult offenders. So this station has been determined to only apply for to adult offenders. You should refer to your local statute to define the legal age of an adult or offender. Next slide, please. I can see the approaches of funds. Well, BJA recognizes the comprehensive range of program required to have a successful reentry program. And so there we have, as broadly as possible, to include service that you could provide. We're focusing, like I said, on evidence-based programming, and you can see here where it starts referring to some of those, especially the last two bullets. When we talk about 6 months of case management supervision post-release, and targeting once the offender's transition into the community, and to use funds for graduated sanctions. We would look for applicants to focus on high risk, because there is evidence to show that that's where we will be most successful in reducing recidivism. Stated earlier, that is a goal of the Second Chance Act. Advance slide, please. Finally, there's a National Institute of Justice evaluation with some of our reentry court grantees. Successful evident applicants could potentially become part of evaluation. So you will see in the application several requirements that you have to agree to in order to apply for this grant. Advance slide, please. Priority consideration. So here you see the first bullet mentioned are medium and high risk offenders. So we will be giving priority consideration to people that focus medium, high risk offenders. And we talk specifically about the evidence-based practices that are listed on page 7 in the solicitation. And so what a priority consideration means is that once we do peer review and scoring, which I'll talk about in a minute, that the Bureau of Assistance has the discretion then to look at applicants that are have a one of the 5 priority considerations, and then we can determine funding based on you addressing those priority considerations. So in your application and think about applying, I highly recommend that you focus on some of those priority considerations. Advance, please. Notice of new post-award reporting requirements. I'm not going to go over that. I think it's very self-explanatory, and if you have any questions, we can talk those in the end. Now, advance slide, please. So, criteria. So this is the most important part of a grant application. And I talk to a lot of people all the time that wonder how do you successfully apply for a grant. And I tell them that it's simple. This is where it all happens. If people would answer the questions just we have written them, because this is where all the scoring comes from, this is what's peer reviewed, then they will score well on an application. So I urge you to follow the statement of the program design, everything laid out in your application. Answer the question, line by line. Because in peer reviewers, I don't know if any of you have been a peer reviewer before, this is exactly what we look for. We've gone through and worked very hard to write this section in order to score applicants to get what meets then the purpose of the Act. So please follow selection criteria and write your application, advanced slide please, to us exactly what's listed. So the statement of the problem comes up first. I don't think I have any. Yeah, I think it's pretty explanatory. We've done the best we can to make it concise and not repetitive. You have my information. If any of you come across things you would change, we would love for suggestions. Because we worked very hard this year to try to make it clear and concise, because I know reentry courts is a little concept that I don't know that everyone's gotten their head around. It's a slide, please. Okay, I mentioned different interpretations of a reentry court, and so I want to spend a minute and talk about reentry courts and the two possibilities under this solicitation. You'll see on the first bullet, it talks about either judiciary or executive branch involvement. And so in that, federal level, it's like an Article 2 or an Article 3 court. So at the state and local level, I think it's like your executive branch, which is your, and then the judiciary branch, which is, for now, we'll say everything else. So under this solicitation, your executive branch, your parole, can apply to a reentry court, and then the actual court jurisdiction lies with the parole board and their power to the jurisdiction over, not power, jurisdiction over the offender. So that's one way you can have a reentry court. We have several examples at the end of the citation where it talks about the two different courts. Or you have a court where you have the judiciary that has jurisdiction. And under that one, it's determined by your state laws. We see it most as states with split sentencing, where the court retains jurisdiction. But also when offenders are on probation, depending on the agreements in your state law, that's the jurisdiction and the court piece of the reentry court. Okay, advanced slide, please. So capabilities, competencies. We want to make sure that you have the management structure and staffing, and we want to know what everyone's roles and responsibilities are. What we recognized is that in order for reentry to be successful, there's a lot of partners required. And so I think that's on a different slide, but we want to know how those partners are going to work together under this section. And then there's a book that talks about the NIJ's evaluation. Next slide, please. I think this is self-explanatory, and it's to please answer every bullet in order in your solicitation, and that's the way they're peer-reviewed and scored. Advanced slide. So the question that I mentioned earlier is a requirement that we've put in this you see it's listed on page 16 of the solicitation. And we want to know all the partners and detail their role. And we ask for a letter of commitment from all the agencies that are going to work with you. Now, this is not, it doesn't rise to the level of a memorandum of understanding, and I know sometimes it's difficult to get certain from certain agencies, but because it takes everybody working together, sharing information for the reentry to work, we were requiring a letter of commitment from all your partners this year. Slide, please. So on the most important point is the 50% match. And I know this is a difficulty for a lot of people at this time. It's a requirement in legislation, and the requirement is 5% in-kind match, 25% cash match. And that will be detailed in your budget, in your application. Slide, please. For measures, they're listed there, and that's requires you to discuss in your application your methods for collecting the data related to the bullets listed on your slide. And it's very important to think about these and designing your program or enhancing your program and then applying for solicitation, because we're required, the National Reentry Resource Center, CSG, and BJA, to report to Congress on the reduction in recidivism. And so it's very important for us to have you think about these in the beginning of your program and then continue working with us through the period of the grant, collect all this information so we can report back about our success. Slide, please. And I think that's the last one for me. You have the assistance contact information, which is a hotline, support.gov, and then the Justice Information Center, which is questions for BJA. And if it's a substantive question, then we'll come to either me or Brenda, and then we will either answer you directly or work through the Justice Information Center. But they're a resource to have. Okay, I think.
Great. Thank you very much, Kim.
Okay.
We're now going to begin the question and answer session. As I said before, and some of you have already figured out, if you'd like to ask a question, please type the question in the Q&A panel, which is at the bottom right hand of your screen. I'm going to read the questions coming in from the audience and then give our panelists time to respond. And we'll do our best to answer as many of your questions as possible in the time remaining. So, Kim, one of the first questions that came in is, if you've received a Second Chance Act grant in the past, are you eligible for this grant?
We are in the process of working on supplemental funding, but you are eligible.
Okay, great. And Brenda, there's a question about when funding would start. So if folks are writing up a proposal for their budget and their timeline, when should they anticipate receiving funding?
Period should start on October 1st, 2011. The grant notification of awards are typically sent during the September timeframe, but no later than September 30th.
Okay, super, thank you. And Kim, related to that earlier question, can one jurisdiction apply for multiple Second Chance Act grants? So can they apply for a reentry court grant at the same time they're applying for a demonstration grant?
Yes, they can.
There's a question for either of you. One of the participants in the webinar would like to know if the Office of state court administration counts as a court for the purposes of this solicitation?
Office of State Court Administration. So, is there any? Can we go back and forth? Is there state
Yeah,
AOC?
sure.
Can
Yep,
you,
it is their
is that,
state AOC. Yep.
they are eligible? Yes.
Yep. Okay, I'm just going to keep the question answered there. I'm going to just try to group the questions about the match together because we always have a number of those. Right. Can other grants be used as part of the match requirement?
That question can actually be answered by referencing both the OJP Financial Guide, Part 3, Chapter 3. It's titled Matching or Cost Sharing. And more detailed information regarding what is eligible as a match is also referenced in the OJP Financial Guide, and that can be found in the Code of Federal Regulations, and that's at 28 CFR 6.24.
Just sending to all the participants the name of the publication that Brenda was just talking about.
And the Grants Management Common Rule.
Okay, Brenda, if a potential applicant is having technical difficulties submitting their grant, what should they do? Submitting their proposal, what should they do?
Sure. With regard to technical issues, please reference page 13 of the program solicitation. It will give you very detailed information on what to do. Basically, you need to report your issues within 24 hours after the deadline and request approval to submit your application, and these must be reported to BJA. BJA will then verify the technical issue with grants.gov to validate, to determine whether you will be permitted to still submit your application. The solicitation document also details the reasons that are not valid for submitting a late submission.
I would like to add on this response to please document any contact you have with grants.gov regarding your issues, because it is something that we look at in considering late applications, and take down the names of people we talk to, and I think they give you a ticket number, and so keep detailed information if you're having trouble, and then that way you can just submit it all to BJA, and then in determining that, it will make it easier for us.
Great, thank you. At one point, the solicitation mentions that federal funds should supplement and not supplant state funds, and somebody had a question about exactly what that means, or if there's an example you can provide to illustrate that.
Sure, I can take that one. With regard to supplanting, basically, you cannot use the grant funds for a purpose that you already have funds available for. It must supplement the project.
Brenda, can you give an example of that, or?
I would say an example would be if you have a state employee that already is paid by the state, and that's their salary is already within the state budget. You cannot then use the grant funds to pay for that employee.
Okay, perfect. Thank you. There's a question about whether there is any potential for waiver of the cash match given the current budget climate.
Fortunately, no.
The question here about how the 10 key components for drug court are related to reentry courts. The questioner asking, noting that in last year's solicitation there were some key components, and wants to know whether those are it's still required that you address those.
Say I'm not familiar with last solicitation. I worked on years when we changed it, so if it's not in the solicitation this year, if it's not part of that selection criteria, then no. It's only what's in the selection criteria, and I just pulled it off my screen. We can go back to program design. I'm guessing, let's see, here we go. It probably where it was. Let's see, statement of problem. Program. The solicitation is organized very differently than it was last year. And because we do not have a model that supply research for reentry, there aren't any components that we are recommending. As you can see, we did the priority considerations and given examples of evidence practices with supervision and monitoring, and then gone through and tried to let jurisdictions design their own program based on what we know as evidence-based practices.
Mm-hmm. Great, thank you. There are a couple of questions that have come in about existing programs. So if a jurisdiction has been a grantee for the reentry court solicitation in the past, are they eligible to apply this year? And if they're, and I'll make it a second part question just to make it a little bit more general, if they're receiving other funding from BJA for a drug court or a mental health court, are they eligible?
Okay, I thought we already answered number one. Is that the same one, Hallie, our very first question, isn't it?
No, some people are asking if they received a reentry court grant last year. So not reentry under Second Chance Act, but reentry court specifically.
Oh, reentry court specifically. So then I think I answered the first one incorrectly. So when the first one, I was answering it for reentry court that was currently working on supplements for the F2010, but that if you meet the requirements, you're eligible in the competitive if you don't get the supplement. And one is if your court is getting drug court money, are you eligible? I think that would work. I mean, if you had a reentry, so you have an existing drug court, and you want to do a reentry, say track or docket or program as part of that court. Yes, you could, and then that piece, I mean, your new or enhancement, you could call it either, reentry piece would have to meet all the selection criteria, and you have to be very good with your accounting and making sure the funds the drug court went to pay for drug court activities, and the reentry court funds went to pay for reentry court activities. That's correct, Brenda?
Must be able to separate the activities for each grant.
Okay.
Thank you for walking through all those different permutations.
I hope that answered that. I was trying to, yes.
Yeah, I think that was clear.
Okay.
And we have two follow-up questions from some of the ones we asked earlier, so
Okay.
I'll try to link it back to the initial question. So the initial question was whether an Office of State Courts Administration can be an applicant, and we had said yes. And so somebody is just following up to clarify that the Office of State Court Administration is the applicant, do they need that agreement with the court? Or do they, since they're the Office of State Court Administration, they're covered on that respect?
That'd be, and also, if they're a unified or ununified state. So in some states, the Office of Administration of the Courts controls, and funds all the states, all the courts in the state, and in some states they don't. So it's a case where, they're applying for the local court, then they wouldn't have to.
All right.
They may want to talk to me offline.
And how would you want folks to contact you if they have questions?
The questions are supposed to go through the Justice Information Center, but I'll give you, I'll give an email out for people to email me directly about substantive questions. So I'm going to do this for everyone, but remember, all your application questions. I can't ask GS and EIN, all that requirement information. I can't help you with. You've got to go to the Justice Information Center that's listed in the section and on the slides. But if you have a substantive question about the selection criteria, you can email me. It's my name. It's kim.norris@usdoj.gov.
Okay, and I'm going to send that. I'm chatting that to the participants. So
yes, with that court one,
you should see Kim's name for substantive questions only and her email address. All right. And Brenda, we just had a follow-up on the supplementing and the match. Somebody wanted to confirm an employee already paid with state funds could be used for the match, correct?
With regard to the match, non-supplanting also applies. The match is restricted to the same use of funds as allowed for the federal funds.
But that could be in-kind match, right, Brenda?
It's still restricted to the same use of the funds. So the circulars are very specific about non-supplanting.
But if someone is willing to have a state-funded person dedicated to a reentry court, it counts as, it can be used 25% in kind.
It really depends. So that's more. I would suggest that we take it offline for that.
Oh, okay.
And there clarification when you said nonprofits are eligible as grantees. Somebody wanted to know whether the nonprofit has to be a 501c3.
You do.
Okay, great. Love yes/no questions, right?
Yes.
And here's a question. I'm not sure if there's an answer to this one, but somebody wants to know how much is available as a total amount for applicants for this grant.
Oh,
so I guess the question is for each grantee.
It's 5,000, correct?
Mm-hmm. Yes.
Correct. And when we skip a slide, there's a okay. Amount and length of award. Awards will be for 12 months with the possibility of no-cost extensions. He may be eligible for continuation funding for additional 2 years, contingent upon the funds and whether they demonstrate adequate progress toward meeting the established goals of the program, and contingent upon the availability of funds, award approximately $500,000 will be made. But remember that match requirement.
Great. And Kim, somebody if you could talk a little bit to here's something that doesn't have a yes or no question answer. They're asking if you could talk a little bit about medium and high risk.
Oh, wow. That's, oh, God, can you, I can.
Sure.
Okay, thank you. That's more. That's actually your expertise, not mine. Put you on the spot, though.
No, it's my pleasure.
Okay.
This is, as you'll see in the solicitation, there are a couple of links to where the National Institute of Corrections or the Bureau of Justice Assistance has laid out evidence-based practices for corrections, for adjudication, for community corrections. And so there's actually some links that discuss instruments for screening high and medium criminogenic risks and needs. So I think in this case I would refer the person to the solicitation, which has some information about evidence-based practices and also talks about how screening and assessment for different risk and need levels can correspond with different types of programming.
But ultimately, that screening tool determines whether they're medium or high, correct?
Mm-hmm. Mm-hmm.
Yes. So then, yeah. So yeah, they need to look at that screening tool and then know once their group of offenders is screened, the ones we want them to treat are the ones that then are indicated to be medium and high.
This is a question about, I guess, supplemental awards. And the question is whether supplemental awards will be made known in time to know whether existing grantees need to make an application through this solicitation.
Yes, they will.
Okay, great. And do applicants need to establish a collaborative relationship with a drug court or a reentry court?
Do applicants need to establish a collaborative? Well, it depends on who the applicant is. That's you have to have a court as your partner. So I guess the answer is yes. I don't. Do you have to establish? I don't. That one's a little vague for me because of you have the judicial, either the judicial or the executive branch oversight.
So if the questioner would like to add some supplemental information so we can help tease out the question, but I think the answer that I'm hearing is that if you are not a court, you need to have an agreement with a court, but you do not need to have a relationship with an existing drug court. That's certainly not a requirement.
Right.
Paging through the questions here. So there have a lot of questions from programs that have reentry court grants this year. After the back and forth about this, there's one question for clarification to make sure she understood the whole chain. Am I understanding correctly that since we were a reentry court grantee last year, we may not need to submit an application?
Correct. We need to, there are, and some of the FY10 are being supplemented and some are not. So I need to get that information out there. I learned that from this.
This has been great. Thank you, everybody, for your questions. We'll just stay for a little bit longer to give folks a final opportunity to ask questions.
I'd like to add one comment. This is Brenda Worthington. I just wanted to add to everyone to make sure that you really go through the solicitation document and follow all the instructions and include every single piece of documentation that it requires. That's extremely important through this process.
Great. Thank you, Brenda. That seems to be a big theme from both of your presentations, that a lot of effort has really been made to put as much detail as possible into the solicitation, and so following the solicitation seems like it's a good key. There's a question here about how long is recommended for the pre-release case management period. And I believe that was discussed on one of the slides. I'll just try to pull that up.
Hallie, it says 6 months. On, let's see what slide was the recommended. Oh, where'd it go? Is it under priority consideration? I think it's under approved use of award funds, which is slide number 8. And it says applicants are strongly urged to use consistent pre- and post-release case management and supervision sustained over a period of at least 6 months, and is especially responsive to the offender transition from incarceration to the community. So, that's interesting. Was it 6. Sustained over 3 pre and 3 post.
I'm looking in the solicitation to see
how it is in there.
Yeah. What I was going to say is this solicitation contains a lot of information sort of tying it to content, and so there, if you, especially looking on page 7 of the solicitation, there are links to other documents that can be helpful in answering some of these sort of program design questions.
That answer, and I may have in my presentation have stated that. I glanced at it. I may have said 6 months of pre and 6 months of post, which now looking at this looks like it may not be exactly. Yes, so definitely check all of the references in the solicitation about recommended practices.
And yes, again, I think that Kim said that she will be in touch about supplemental funding, so I'm going to
not ask any more of those. Yeah.
So just a final one to see if folks have any other questions, and I'll remind folks that we'll be sent this webinar it has been recorded and will be available online at the National Reentry Resource Center, and we'll also be sending out a link to it once it's posted. We'll also be sending out a copy of the slides.
I would just like to thank CSG and Chanders and you, Hallie, for putting all this together and out. You did an excellent job.
Oh, thank you. It's our pleasure. Our pleasure. All right. Are there any other final words from Kim Ball-Norris from BJA or Brenda Worthington from BJA about the reentry court solicitation?
Not from me.
I'll add one final comment. Please make sure that you begin your application process early. There are several different steps that are time sensitive, so it's very important to get all of this started early so that you will be sure to have your application in on time by the deadline. And thank you all for participating.
Great. This concludes Second Chance Act grants, state, local, tribal reentry courts. This webinar was made possible with funding support from the U.S. Department of Justice, Bureau of Justice Assistance. When you exit the webinar, a brief survey is going to appear on your screen. Just like the reentry court grantees will have performance measurements, so do we. And so it's very, very helpful for us if you complete a survey to let us know how this has been as a learning experience for you. We really appreciate your taking the couple of seconds it takes to answer those questions so we can let BJA know how this webinar served the field. Thank you all for your attendance and your participation, and a special thank you for our two presenters from BJA. We really appreciate their time and effort in making this presentation so that folks have more information about how to complete their solicitations. As I said earlier, we'll be emailing a link of the recording of this presentation in the next few days, and the link will be available, as will be the recording, at www.nationalreentryresourcecenter.org. Thank you all very much.
Thank you. Bye.